want to tangle with me. I know the law.
Protest arrests exist because your constitutional right to free speech is not absolute. Even in the most traditional of public forums, your right to assemble may be limited by reasonable time, place, and manner restrictions so long as they are viewpoint neutral and narrowly drawn. These restrictions, generally propagated to ensure safety, often take the form of permits, protest-free zones, designated protest zones, hour restrictions, noise limitations, and signpost bans. When protesters fail to remain in the designated protest area, they can be cited for trespassing and/or impeding the flow of traffic. When protesters violate noise ordinances, time restrictions, or assemble without a permit, they may be cited for disturbing the peace. When protesters act in an unruly manner or impede sidewalks, they may be cited for disorderly conduct. But when protesters fail to follow orders given by law enforcement, they almost always earn themselves a protest arrest. Regardless of whether you like the outcome, for decades these sorts of laws and limitations have been approved by the courts. As such, they are enforceable statutes, meaning that a protest arrest based on their violation is wholly within the law.
We don't have any drugs in the state of Georgia. We got your license plate.
Certain state and local laws prohibit behavior that could be considered disruptive or threatening to public safety or the general peace of a public area, such as playing loud music in front of a restaurant or inciting violence in a public park. Public safety violations include disorderly conduct and disturbing the peace, which are considered catch-all violations for actions or words that compromise the safety or overall peace of public places, varying from state to state.
Law enforcement that's watching my video and plugged in, the lady that assaulted me the other day, that I decided not to press charges against. I may be up there to press charges against her because I do have the video of her touching my nose, and I will be down at the sheriff's department or the police station today around 1 or 1:30.
Disturbing the peace and fighting words. In order to get convicted of provoking another person using fighting words, the district attorney must prove, beyond a reasonable doubt, that you used offensive words which were inherently likely to provoke an immediate violent reaction, and those words were directed at one or more persons and spoken in a public place. What about the First Amendment? This offense is essentially an exception to the right of free speech that is otherwise guaranteed by the First Amendment to the United States Constitution because courts have held that the types of offensive words that this subdivision prohibits necessarily invite a breach of the peace.
Georgia, you don't want to tangle with me. I know the law.
A person commits the offense of disorderly conduct when such person commits any of the following: acts in a violent or tumultuous manner toward another person whereby such person is placed in reasonable fear of the safety of such person's life, limb, or health. Acts in a violent or tumultuous manner toward another person whereby the property of such person is placed in danger of being damaged or destroyed. Without provocation, uses to or of another person in such other person's presence opprobrious or abusive words which by their very utterance tend to incite to an immediate breach of the peace, that is to say, words which as a matter of common knowledge and under ordinary circumstances will, when used to or of another person in such other person's presence, naturally tend to provoke violent resentment, that is, words commonly called fighting words, or without provocation, uses obscene and vulgar or profane language in the presence of or by telephone to a person under the age of 14 years, which threatens an immediate breach of the peace. Any person who commits the offense of disorderly conduct shall be guilty of a misdemeanor.
Yeah, you guys send these trash bags out here for representation. It makes you guys look wholly disgusting. honesty. Nobody has respect for the hate side. This is crackhead 1. Crackhead number 1. Yeah, this is the original. The original crackhead. Yep.
Considerations in determining sufficiency of provocation. Sufficiency of provocation depends not only upon language employed, but upon relationship of parties, state of feeling existing between them, tone, manner, and spirit in which language is used, and other circumstances from which jury may in some instances determine that words apparently or ordinarily innocent afforded reasonable cause for provocation under the circumstances or in the manner in which they were used. Fact that opprobrious words are true is not a legal provocation for their use. Evidence was insufficient to sustain defendant's conviction for disorderly conduct arising out of an incident, in which defendant drove by a police officer, yelled "You bastards" out of the window, and continued down the road because the words used by defendant did not constitute fighting words under O.CGA, Section 16-11-39A3, in that defendant was not engaged in a face-to-face confrontation with the officer tending to incite an immediate breach of the peace when the words were spoken, but instead, defendant continued to travel past the officer in defendant's vehicle. Turner v. State.
Utterances which are no essential part of any exposition of ideas, and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Bro v. State. Language is obscene, vulgar, or profane when, under circumstances and manner in which such utterance was made, it would clearly offend a reasonable person's sense of decency. Bro v. State. Evidence was sufficient to sustain fighting words conviction of schoolteacher who told student, "Go to the bathroom and beat off." Schuler v. State. Officer's testimony that defendant used disgustingly profane words which disparaged the dignity of motherhood, childhood, and the intellect of police officers while defendant was being served with a traffic citation was sufficient to authorize finding defendant guilty of using fighting words. Nunn v. State. Defendant's comment to a female during an interview that, "You have nice tits," did not constitute language so opprobrious or inherently abusive as to be fighting words within the meaning of the law. Lundgren v. State. Evidence of explicit swear words that defendant screamed and cursed at a victim was sufficient to support defendant's misdemeanor. Disorderly conduct under O.CGA, November 16, 39. McCarty v. State. For the use of obscene words to constitute a disturbance of the peace, it must be made in the presence of a member of the public and not merely a police officer. Woodward v. Gray.
You don't want to tangle with me. I know the law.